I don't know about these days.
Not
But
these days.
it's also lunchtime.
Okay. Good morning. Is it, or no, good afternoon now, right? Good afternoon. Thank you for joining us. Can you hear us in the back? No. It's green. Oh, here we go. Okay. All right, good afternoon. Thank you for joining the panel on Indigenous Languages. My name's Diana Pizarro. I'm the Global Coordinator for Indigenous Peoples for the World Bank, and I've been asked to moderate this session. We have very renowned speakers on our panel. I'm first, though, logistically supposed to read a few reminders to everyone. First off, for CLE credit, any person attendees seeking CLE credit must find one of the ASL volunteers, white ribbon on their badge, and check in. They must do the same upon departing. Credit cannot be awarded without this taking place. For panels where folks are watching live but virtually, CLE recipients will be contacted after the annual meeting to submit a self-certification form. In regards to participation, we'll be asking questions through an annual meeting app. So any questions that you have, please go to the app and submit them through there, and we will receive them on the tablet and field them to our panelists. There will be no microphones for people to ask questions, so those are the reminders. I mean, do we have there is not a microphone, and I believe there are people participating virtually, so that's our limitation on that one, yes. Okay, so we have an hour, and just a few opening remarks from me. I think, first off, language often is sort of reduced to some sort of, this is part of a cultural thing, a heritage, but it's not really seen as, I don't think we're visualizing it with the power it has to transform our lives and connect us with people. Language is intrinsically linked with how we define who we are. It sets us apart as a group of peoples and defines our interactions with actors, both internal and external. It serves as a factor driving how we self-identify and recognize by others. An example of this that's very important where I work at the World Bank is our Indigenous Peoples Standard 7 includes language as one of the 4 criteria we apply to define who we consider Indigenous and thus imply certain rights and entitlements under the projects we finance. Through language, we can express, define, and achieve what we aspire. Language can serve as a catalyst to connect, understand, access, and leverage the resources of which we have. Language is the primary vehicle through which we pass on cultural values and the ways of life over generations, and through which we grow and evolve as human beings and societies. At the same time, language can serve as a barrier to connecting and interacting with other parts of society. It can serve as a driver of exclusion to accessing services and opportunities, critical to our survival and growth, and to participating in our economies and decisions that affect us. Another example from the institution I work is that we require that stakeholder engagement is done in ways that the stakeholder in local languages and manners that are accessible and culturally appropriate. We'll hear more about that from Leo. As many of you know, we're starting the decade of Indigenous languages in 2022, and the UN outcome document that proposed this decade highlights that more than 7,000 languages are spoken on the planet, a vast majority of which are Indigenous. At the same time, 40% of these are at risk of extinction. Lessons from the Year of Indigenous Languages in 2019 noted that this extinction is being driven by social, economic, and political exclusion, including discrimination and disrespect of human rights and freedoms, as determining factors of the loss of linguistic diversity and wealth. Today, our panelists will draw on their vast experiences to ground us in why Indigenous languages are vital to cultural survival, respect for human rights, inclusion, sustainability, and the right to self-determination. It is our hope that with their insights, all of us can leave today with greater awareness and sensitivity around the relevance of Indigenous languages and what more can be done for their preservation, revitalization, and promotion as we move into this decade of Indigenous languages. So I would like to introduce our first panelist, who is joining us virtually. There we are. Let me find. Great. Thank you very much. Professor Kristen Carpenter is a Council Tree Professor of Law and Director of the American Indian Law Program at the University of Colorado Law School. Professor Carpenter served as a member of the United Nations Expert Mechanism on the Rights of Indigenous Peoples from 2017 to 2021, and as its chair in 2019 and 2020. While serving at the United Nations, Professor Carpenter worked on rights issues regarding Indigenous peoples throughout the world and represented MRIP on the International Year and International Decade of Indigenous Languages. Professor Carpenter teaches and writes in the fields of human rights and Indigenous peoples law with emphasis on rights to land, culture, religion, and language. She is an author of dozens of academic articles and several books on these topics. With colleagues at the Native American Rights Fund, Carpenter is co-lead of the Implementation Project, an effort to realize the aims of the UN Declaration on the Rights of Indigenous Peoples in the United States. She is a graduate of Dartmouth College and Harvard Law School. So, Professor Carpenter, many thanks for joining. Could you speak to us a bit, giving us framing of the decade of Indigenous languages, the relevance for human rights, and how language serves as an enabler to access quality and culturally relevant services? Thank you so much, Professor Carpenter.
Thank you, Diana. I appreciate being here with all of you, even though I am virtual. I'm in Albuquerque and attending the Federal Bar Association's annual Indian Law Conference, and it's good always to have the domestic and international connections. Diana, before I proceed, may I ask, can you hear and see me pretty well?
Perfectly. Thank you.
Okay.
And your presentation.
Okay, great. Well, and greetings to my fellow panelists. I'm sorry not to be there in person and with the audience as well. So I think I'll start with the UN General Assembly resolution declaring the International Decade and share a little bit of that language, but then also talk about why we need a decade and how it's proceeding, as well as goals for the decade. And so, as Diana mentioned, the resolution is meant to draw attention to the critical loss of Indigenous languages and the urgent need to preserve, revitalize, and promote them, taking steps at the national and international levels. UNESCO is the lead agency for the decade and was also for the year. And the decade is being run by a global steering committee, a global task force, I should say, with representatives from Indigenous peoples and states throughout the world. And of course, it's UNESCO, so it's based in Paris, but there have been meetings everywhere. More specifically, the resolution does a few things and of course calls on member states to participate actively and to establish national mechanisms to implement the decade, and invites Indigenous peoples themselves to be involved with the implementation effort. So one of the reasons, of course, why we need an international decade of Indigenous languages is the precarious status of them, as Diana mentioned. And as the slide here indicates, the levels of endangerment are very high. For a while, language advocates were describing that as many as one language was going extinct every 2 weeks. I think among language activists, the language and orientation has really changed because we're thinking of languages as perhaps going dormant, but being open to reclamation and revitalization. And so the focus is much more forward-looking than it was on that previous language of extinction. In addition to the languages themselves and their vulnerability is, of course, the vulnerability of people who speak them. And I think this is the second prong of why we need the decade. And in terms of human rights, people in this audience probably know that language is a human right, and it's also essential to the realization of other human rights that are necessary for human dignity and survival. Just to recall a few provisions that you probably know from the Universal Declaration of Human Rights, speaking a minority language is a matter for equality and non-discrimination. And under the International Covenant on Civil and Political Rights, there's the General Minority Rights Provision, Article 27, that provides that minorities shall not be denied the right to use their languages in community with others. And there's also, I think, importantly, Article 14, which mentions that in criminal proceedings and potentially others, individuals have the right to be informed of charges against them in a language that they understand. And there are other provisions about meeting with attorneys and due process and so on. So we have a pretty strong basis, both in the social status, the situation of Indigenous languages, and in the human rights framework. But as we turn specifically to Indigenous peoples, the current situation is that these fundamental human rights are quite often denied to them. And in an article that I wrote with Alexei Sikarev, who serves on the UN Permanent Forum on Indigenous issues, we did a global look at Indigenous peoples and language rights. And we also did a comparative study from our own two home countries, the US and Russia. And these days, it doesn't seem like the US and Russia have too much in common. One thing they do have in common, unfortunately, is that Indigenous peoples are dying over language rights or the denial of them in both places. There are two stories that we tell in the article, and of course, they're very serious stories, but they're also broadly illustrative. In 2019, just when we were on the cusp of the International Decade, a little girl, Jacqueline Kahl-McKean, died in the US in Customs and Border Protection custody, having just crossed the border from Mexico with her dad. And she was gravely ill, but her dad signed the entry forms attesting to her good health, unable to speak either in English or in Spanish, and denied any interpretation services. And because they couldn't report her healthcare situation, she died, I think, 27 hours after entering the country, not because the medical services were unavailable, but simply because she could not be understood in her language and no translation was provided. Across the world in Russia, the very same year, the Udmurt scholar Albert Razin died by self-immolation when he was protesting oppressive language policy in Russia that was further going to constrict Indigenous and minority language rights. And this was a matter heavily covered in the press and not particularly appreciated by the Russian government. But I should say our own government, the United States, is really not doing much of a better job with Indigenous people's language rights here. And so as a point of departure, I think we could say that in the US, in Russia, throughout Latin America, throughout Asia, throughout Africa, Indigenous peoples are being denied language rights. And these have both historical roots and ongoing discrimination. And I don't have time to go in great detail through the historical record, but many of you may know that in North America, for example, we long had residential schools, which were specifically charged with eradicating Indigenous people's languages, often forcefully taking children from their home communities, forbidding them to speak their languages, teaching English or French, along with religious instruction. There were many other historical policies, and there are some that still exist in our country and elsewhere where monolingualism is required either in state government practice or it's the de facto language of instruction in public education, where we don't have anything resembling equality when it comes to the right of Indigenous peoples to use their own languages in voting, employment, health, and so on. The image here is of the federal boarding school period in which the goal was to turn little Indian kids into little assimilated white aspiring kids with English language skills as a part of that. Today, the ongoing repercussions are, in these same realms that were attacked, not only culture, as Diana said, but also the other categories noted here. And just in the two images, I think, again, you could make comparisons around the world, But in Australia, only just over half of Australian Aboriginal people are registered to vote. Recent studies in Nunavut, Canada, trace deleterious health outcomes to the failure to provide services in the Indigenous language. And we could really, cast our eyes around the world and make similar observations elsewhere. And so the Indigenous peoples movement over the last, well, in many communities, this has been happening everywhere, but over recent decades has really identified Indigenous peoples' language rights as a subject of concern, again, focusing both on the vulnerability of the languages and discrimination against the speakers themselves. I apologize that I'm going a little bit quickly, but I want to set the scene with as much context as I can. In the international and UN arena, the discourse is very much about rights, of course, but is also about other aspects of Indigenous languages and how they contribute to society more broadly. Indigenous languages, as I'm sure some of the speakers will touch on, uniquely capture aspects of knowledge, especially traditional ecological knowledge. They have a lot to do with diplomacy and relations among peoples in local settings, rights we've talked about, and inclusion of Indigenous peoples in many of society's processes and institutions. And so the framework for the International Decade is very much based around human rights. And it also touches on the Declaration on the Rights of Indigenous Peoples, which takes some of those universal rights from the UDHR and the ICCPR and other instruments and puts them into the context of Indigenous peoples' realities. I'll talk about those in just a second, with the goal being a plurilingual future of inclusion and equality. To mention two of the articles in the UN Declaration on the Rights of Indigenous Peoples, which was of course adopted by the UN General Assembly in 2007, there is this basic Article 13 that Indigenous peoples have the right to revitalize, use, develop, and transmit to future generations, and states have an accompanying obligation to take measures to ensure this right is protected. On the right, I have an image of the Cherokee syllabary. It's cut off a little bit. In many countries, national policies have gone so far in favor of monolingualism as an instrument of national identity and national dominance that they've even outlawed the scripts of Indigenous languages, which was one of the things that communities along with oral tradition are really working to bring back. Article 14 speaks specifically about rights to language in educational settings. And I think this is twofold, that Indigenous peoples have the right to control their own educational institutions and to teach their languages in them. I'm going to skip a little bit on some of the thematic points, as I think that we've hit on them before, and draw out a couple of the international points and then conclude with some things happening in the United States. So I served on the UN Expert Mechanism on the Rights of Indigenous Peoples, and in the years leading up to Declaration of the Year and the Decade, we did some studies around language and culture. And I think I'll point to the bottom two bullets. One is that, like any international rights, they have to be realized nationally and locally. So it is absolutely the job of Canada, Australia, the United States, Belize, Peru, et cetera, to come up with law that realizes these international rights. And secondly, Indigenous peoples must be deeply involved and they must have the opportunity to provide their own input and their own consent when it comes to developing these language laws and policies. It can't be a top-down effort, it has to be a bottom-up effort. And I think fortunately, we've seen again around the world, but I'll focus on North America here, Indigenous peoples really stepping up to the plate to participate in this International Decade of Indigenous Languages. In 2021, in North America, we had a series of consultations to develop input on the Global Action Plan. Of course, they were happening on Zoom because of COVID. But you see here only one of the 5 or 6 screens of Indigenous peoples participating with state representatives in that process. And then I was especially proud to see the Cherokee Nation host the first launch event for the decade in the United States. The United States government itself has really been quite slow to come to the table on the International Decade. It has issues with UNESCO. We could just talk about those in the Q&A. But the Cherokee Nation and other tribes have stepped up where the United States hasn't, in comparison with Canada, which is totally at the table, Australia, Norway, Russia, and so on.
Professor Kristen, I'm sorry, we're just
yes.
going to have to, if you could just start wrapping up because we're a bit over time.
Yes, okay, I'm on my last slides. Thank you, Diana, and I'm sorry if I'm losing track of time. So I think some of the things that we see from these communities in this bottom-up approach are that, you know, every Indigenous people has a different language situation. You can contrast the Wampanoag people who are bringing back their language from dormancy with Cherokee Nation, where there's a written language, Navajo Nation, which has uses its language in its court proceedings and so on, and Hawaii, which has worked with the Maori people and really developed successful language nests and other processes. So as we're looking for recommendations for states, and especially the United States, I think paying attention to what we're learning from Indigenous peoples, declaring support for the decade. The tribes have asked directly the Biden administration to do so. It hasn't yet done so. Announcing a national action plan for the decade, remedying past harms, ensuring future rights. Those are all really important components. And hopefully that'll result in some on-the-ground reform and also to the national pieces of legislation that I mentioned below. With that, I will conclude. Thank you, Wado and Cherokee, the language that I'm studying, and greetings to all of you. Thank you for your time.
Thank you so much, Professor. Just one note, we've been getting some complaints about an echo. We understand there's nothing that can be done to fix it. It was through the Zoom. Hopefully now that we go to in people's speakers.
Recording in progress.
We will be in a better place. Also, I need help with this iPad because it seemed to switch to a different space, so I'm not seeing the questions anymore. All right, let's move on to our next panelist, Leonardo Cripa, Coya, from the Coya people of Northwest Argentina. Leo, we'll refer to him as Leo, is a staff attorney or senior attorney at the Indian Law Resource Center. And he received his law degree from the Universidad Nacional de Tucumán in Argentina, as well as an LLM degree from American University. He previously worked at the Center for Justice and International Law in Costa Rica, and for almost 20 years, Mr. Cripa has practiced law in the field of human rights and advocated for the enhancement of multilateral development banks, policies, and procedures, like the ones I represent, especially those aiming at safeguarding Indigenous peoples from environmental and social harm due to bank-funded projects. He is engaged in the development of the American Declaration of the Rights of Indigenous Peoples, adopted by the General Assembly of the Organization of American States in 2016. Mr. Cripa has also represented several human rights victims and Indigenous communities in cases before both the Inter-American Commission on Human Rights, based in Washington, D.C., and the Inter-American Court of Human Rights, based in San Jose, Costa Rica. He is the author of book chapters and law review articles on international law and multilateral development banks. Thank you so much, Leo, for joining us. And we would appreciate if you could touch a bit, hopefully in 10 minutes, on the right of Indigenous languages for self-determination and protection over lands and natural resources. Thank you, Leo.
I'll do my best. I want to... is it working now? Yeah, it is. Okay. Yeah. I will try to reflect on the importance of Indigenous language in a particular case that is currently pending a final decision by the Inter-American Court of Human Rights in San Jose, Costa Rica. Indigenous languages are critical not only for cultural identity and integrity, as we've heard, but also to enable Indigenous peoples to effectively engage in decision-making procedures concerning their lands, territories, and resources, such as those relating to extractive industry projects on their lands. The first panelist, Christian Carpenter, spoke about the United Nations Declaration on the Rights of Indigenous Peoples of 2007, particularly Article 13.2 states the obligations that states have with regard to Indigenous languages, and it reads, states shall take effective measures to ensure that the right to use native language is protected, and also to ensure that Indigenous peoples can understand and be understood in political, legal, and administrative proceedings. The case of the Maya Quechí Agua Caliente community versus Guatemala, this is the case pending from the court, illustrates how the Guatemalan state failed to inform in the Quechí language the Agua Caliente community with regarding their participation and documents for key decision-making procedures, including a procedure before the Ministry of Energy and Mining, that is the agency tasked with granting permits to explore and exploit subsurface resources in the country, and the procedure before the Ministry of the Environment and Natural Resources. This is the agency in charge of carrying out assessments of projects' potential environmental impacts. These two procedures refer to mining permits, request, and environmental impact assessments instruments filed by the Guatemalan Nickel Mine Company, in Spanish, Compañía Guatemalteca de Níquel, with these two agencies. This company is a subsidiary of Solway Investment Group, a company based in Switzerland and owned by Russians. Basically, what I'm telling you is that the nickel that they get from these communities, territories in Guatemala goes to Ukraine for processing, and it is everything managed by Russians. Neither the mining project-related documents nor the environmental impact assessments, the EIA, were shared in the Quechua language with the Agua Caliente community and other 15 Maya Quechua communities affected by this project. As a result, these communities were unable to understand the project goals, activities, and to engage in these two consultation procedures. Now, we are here before a community that is basically monolingual. It's a community with about 360 members. About 5 members speak Spanish as well, that is, they are bilingual, and they are located in the El Estor municipality in the department of Izabal, where about the 90% of the population is Quechua, is Maya Quechua. Guatemala is a state in Central America with about 60% of the population that is indigenous. Most of them are Mayans. So the importance of indigenous language for public services and for every activity affecting indigenous lands is critical. In 2004, the Ministry of Energy and Mining granted the company the permit to explore nickel in the lands under the possession of the Agua Caliente community, whose definitive land title was pending from the land titling agency called Land Fund, Fondo de Tierras in Spanish. In 2006, this ministry granted a permit to exploit based on the approval of the environmental impact assessment by the Ministry of the Environment and Natural Resources with no input from the Agua Caliente community, nor of the other 15 communities affected by this mining project. It is important here to take into account the following. Guatemala lacks of a law regulating consultation procedures with indigenous communities. Neither the 1997 mining law, Ley de Minería, nor the 2007 law for environmental assessment, control, and follow-up, the Reglamento de Evaluación, Control y Seguimiento Ambiental, established the obligation to carry out dedicated consultations with indigenous peoples when a mining project will take place in their lands and seek to explore and exploit subsurface resources pertaining to said lands. That is, within the public participation period when the EIA is open for public comments, there is no regulation that obliges the company or the Ministry of Mining and Natural Resources to carry out the dedicated consultations with indigenous communities and provide information in the native language. As stated, these agencies failed to provide key project information in the Quechua language. In so doing, they basically violated both domestic and international law. Guatemala's 2003 law on national languages, the Ley de Idiomas Nacionales, provides a legal basis for native language consultations with project-affected communities. It establishes the obligation of state agencies to use native languages in all levels of the executive branch of the government, especially when providing public services to indigenous communities. Let's keep in mind that we are talking about a country with 60% of the population that is indigenous, mostly Mayans. As stated at the beginning of my presentation, according to the UN Declaration, Article 13.2, states shall take effective measures to ensure that the right to use native languages is protected, and also to ensure that indigenous peoples can understand and be understood in political, legal, and administrative proceedings, such as those relating to extractive industry projects on indigenous lands. Apart from establishing the same obligation in identical terms, Article 14.2 of the 2016 American Declaration on the Rights of Indigenous Peoples states that states shall adopt adequate and effective measures to protect the exercise of this right with the full and effective participation of indigenous peoples. The case, as I said, is pending from the Inter-American Court of Human Rights after holding a hearing on February the 9th of this year. In 7 to 11 months, a decision is expected. We believe the facts of this case enable the court to adjudicate over indigenous peoples' full collective land ownership in the country, permanent sovereignty over natural resources, and order the Guatemalan Congress to adopt, for the very first time, legislation to recognize indigenous peoples' self-government rights and collective land ownership, and to reform relevant mining and environmental laws, establishing consultation proceedings aimed at obtaining indigenous people's free, prior, and informed consent. Finally, I want to take the time to thank 15 members of the American Society of International Law's Indigenous Peoples Interest Group who worked hard to develop and file with the Inter-American Court on Human Rights an amicus curiae brief that was filed supporting this case. I also want to personally thank Professor Chris Carpenter. She's one of the 12 well-known and well-respected US scholars and practitioners in the field of federal Indian law who filed also an amicus curiae brief with the court in Costa Rica supporting this case. Thank you.
Wow, thank you, Leo, so much for sharing, and you did it actually in 8 minutes instead of 10. So with that, I will pass over to our next panelist, who is Paul John Murdoch, Cree from Canada, and a partner of a law firm called Avocats. Born and raised in the Cree lands of northern Quebec, Me Murdoch has mastered 4 languages: Cree, English, French, and Spanish. Based in Wimindi, Au Ischi, which I believe is Quebec, Paul John Murdoch's practice encompasses a range of corporate, natural resource development, and government relation matters. He is a graduate of McGill University with a degree in common law and civil law. He serves as a secretary and legal counsel to Aboriginal corporations and represents Aboriginals in business activities. Me Murdoch was also president of an important Aboriginal business consortium, resulting in the execution of more than $410 million in work and services by its members. Me Murdoch has extensive experience with regards to Aboriginal relations with governments, federal and provincial, and crown corporations. These relations include the negotiations and implementation of treaties and natural resource development agreements. He has been involved in the design of international projects with indigenous peoples in Argentina and Panama. He has been engaged by the World Bank to provide instructions to directors on best practices for establishing viable communications with indigenous peoples in a development context. Thank you very much, Paul John, for joining us today. And we're going to ask you to speak a bit around how indigenous languages are relevant for self-governance, public policy, and investments. You have 10 minutes. Thank you.
Bomshed Chian, I mean, Naskamo Charles Deleva, Diana Piazzo, Ejibiji Wisham Ganot, and Hatijibij, but Sman Diamonan, Gehozid Wenzid Gawidabungo, motion suggestion and the Witmatia than they would stay at. I always start with an introduction in my language for 2 reasons. The first one is the thanks for the invitation to come and share our story and share the path that we're on. Feels a little bit more authentic when I express it in my language. And 2, it helps me get over nerves and be less nervous before I get into the substance of whatever it is I'm going to speak on. I live in a very, and practice in a very unique situation. In northern Quebec, we have a territory that's larger than France. The only practicing lawyer who speaks the language in that whole territory, so tend to get a lot of work and tend to be quite busy. In our community, we've never really done statistics, but I would guess that 90% speak Cree fluently. Writing, it's significantly less. But Cree is used extensively in our boardrooms, our council chambers, and I was lucky to come in at a time when that wasn't the case, and over the years, as more and more Cree professionals take on different roles. It allows people to be themselves individually and to be more ourselves as a group. So we see our language really taking over in, like I said, in boardrooms and council rooms. The strange thing is, though, I'm the first generation that did not go to Indian residential schools. So my parents, some of my cousins who are a little bit older than me, they did go to Indian residential schools. And knowing what they had gone through, you would think we would be more confident about the future of our language. But it's strange that 90% of the population speaks the language. We speak it in council chambers, board meetings and so on. And yet still you have this sense of vulnerability, and there's a defensiveness or a concern. And it's very hard to manage because it's almost not like, in Indian residential schools, there was a clear concerted effort. We will erase your language. And yet that is not present today, but you almost feel more scared than they did at that time. I do about 60 to 70% of my work in Cree. Even when we're negotiating with governments or negotiating with companies, I always make it very clear to everybody who's on the Cree team, and now we'll have a whole Cree team, just speak in Cree if you want to speak Cree. We'll let them worry about translation instead of it being the other way around. And some very, strange things happen when we do that. Strange good things, not strange bad things. There was one point that I wanted to make, and in witnessing over my career, starting in English and French and moving now into Cree, there's a little bit like when I started, there's a calming effect in speaking your language. There's a grounding effect. There's a legitimizing effect. And the best example of this is my grandfather in my community was a chief, a well-known chief that was respected by fellow chiefs and community members. And we always called him Utzimao, which means leader, chief. His son, who came after him, Billy Diamond, he was called Utzimachan. Every chief elected today is called Utzimachan. And it's almost pejorative, because Utzimachan means man-made. It's not natural. Whereas chiefs before, they were considered just natural. Their authority came from the land. The authority came from their knowledge. You didn't need an actual formal election. Everybody just knew who the chief was. So there was a legitimacy that goes with it. And when you look at both of their administrations, I'm sure if somebody wanted to do a study on it, you see that my uncle had to work a lot harder to keep the community together, to keep people united, to make sure that it was clear that he was speaking for everyone. Whereas my grandfather was able to take it up for granted a lot more. Everybody around him took it for granted. And expressing yourself in your language, the language of the people, there's so much that you can just take for granted because you're in the same context. The minute you're using language that isn't your own, it's immediately foreign. You immediately question the legitimacy of everything you're saying. And I do find that in English and French, I tend to over-justify and almost come across as defensive when I'm saying anything. But when I'm saying it in Cree, I don't feel the need to justify it. The most common piece of advice that I've given to leaders at home or Indigenous leaders abroad: do not engage with a government, whether it's provincial, federal, or even a company, until your house is in order, until you have a vocabulary, or that you, as inside your home, you're on the same page. Just a simple question like, let's not talk about that piece of land and who's going to come and do whatever on it unless it's clear between us what happens when the person who's on it dies, for example. And that tends to happen a lot in mining contexts. The rocks will always be there. We will always be there. There's no hurry. And the value of taking the time to get on the same page as a community before you engage in those discussions, you're not only doing justice to yourself, But even though the proponent probably doesn't know it, you're making their life easier in the long run. When it comes to Indigenous languages and public policy, I'm shocked how at times people don't pay it. The whole debate of form over substance is an example that is just lost if you're not paying attention to what's going on in Indigenous languages. The best example for me here was in the James Bay Northern Quebec Agreement proceedings. So this is 1972, 73. There's basically no such thing as Aboriginal rights in Canada, or they're very, very tenuous. We're fighting for a court just to have standing to introduce an injunction to stop the largest hydroelectric development in our territory. It took years of just getting to the court date, preliminary motions. It's finally the first day of proceedings. The judge is ready, the lawyers are ready, the witnesses are lined up. First witness is an elder who's going to testify to the traditional occupation and use of the territory by the Cree Nation. They're asked to take the oath. Do you swear to tell the truth, nothing but the truth, and the whole truth? And an argument breaks out between the elder and the translator. And then the judge has to intervene and says, okay, what's going on here? And the elder says, well, I'm not gonna say yes to what he said, because I'm willing to tell you everything I know, but I cannot tell you the whole truth. Thankfully, this was a judge who merited his title and his role, because that was enough for him. Because we're talking about establishing the credibility of the witness. Does the witness understand how important the situation is? To have a witness say, I'm willing to tell you the truth, but the whole truth, that shows that that witness has thought of that more than any other witness since that time, probably. And if we're going to get hung up on form, well, we're not going to go anywhere. Thank God, like I said, the judge was concentrating on what we were there for and not just trying to check off boxes. That's the most dangerous things when it comes to... So I'm trying to stay within my 10 minutes here, so I'm going to skip ahead a bit. Integrating Indigenous languages and traditional knowledge, I have seen many times where it'll cost the proponent millions. Hydro-Quebec, because they did not pay attention to the way the term methyl mercury was being translated. It was translated as fish disease. It cost them about $40 million because they had to pay to restore the fisheries because everybody stopped fishing because apparently the fish were diseased. That wasn't the issue. It was methyl mercury was the problem. Seeing the entire uranium industry shut down in the entire province of Quebec because the arrogant CEO did not take a guide like he was told to take and decided to speak to communities on his own. And he didn't realize that until a year later that uranium was being translated as evil rocks. And then he wondered why there was no support for the industry. Not only was there no support, people walked thousands of kilometers to make sure there was an end put to it. I want to share one last story of how profound an Indigenous language can be. Oftentimes in law, even if we're talking about natural resource development or court proceedings, where you're dealing with people in a very vulnerable situation. And I had a friend recently graduate from medical school. This is the first Cree doctor who speaks Cree in his practice. And so obviously we kind of gravitate together because I was the first and still the only lawyer practicing in their language. And something happened to him this fall. He went to see a patient. It was the first time he was going to see the patient. And she was on palliative care. It was the end of the treatment. There wasn't much that could be done. So he was just doing a checkup at the house. And she was there with the family all around. And it was an elderly lady. And he said, when I walked in, he said, I could just feel her anxiety. I could see it on her face. And he said, and the minute I spoke to her in Cree, her face lit up. She smiled. She relaxed. He was able to take her vitals. And he said, you could tell she really calmed down. And he said, and in the 10 minutes that it took for me to turn around and tell the family, look, any day now, but she's doing okay. He said, I turned around, she was gone with a big smile on her face. I mean, the value of that and the cost of the alternative. We have no choice. Lastly, I'd like to thank the American Society of International Law very much, because up in our corner of the territory, it can be quite lonely when you're beside a monolithic, unilingual judicial system, and hearing the experiences of others, seeing these different examples that are being discussed in different forums, feels a lot less lonely. So thank you very much.
Wow. Thank you, Paul John. How moving. All of your stories, examples that tie very closely into the messages today. I have not received any questions through the app, so I'd encourage people to go ahead and field them. I have a few questions for our presenters that we can start with. I'll start with Professor Kristen. And no, your last slide I thought was really fantastic, because you get a bit of a roadmap of different ways in which we can go from words to action around language. And since we all know, I'm being a World Bank Senior Social Specialist, having worked on many projects, when I'm trying to meet the requirement of our policy that all things have to be accessible in the correct languages, and we are maybe doing a national project and there could be 36 different language groups. In practical terms, if we have to prioritize, right, and limited resources we always live in a resource-constrained environment, what would you tell us today as far as, like, if you had to choose one action item or two action items, where would be the priority space that we should all work on to move forward in the decade of Indigenous languages? We can't hear you. I think you're on mute.
There we go.
Now we can.
Okay, great. Thank you, and thank you to Leo and Paul John for your really wonderful presentations. That's a hard question to answer, and I think that one of the luxuries of being sometimes in academia is that I get to be aspirational and idealistic, and really hope that during the decade we'll take a multi-pronged approach. And I think I'm going to answer this in two ways, one very big picture and one sort of maybe more precise, and I invite the other panelists to chime in too. I mean, the really big picture, I think, is to honor Indigenous peoples' self-determination in language policy. And I'm thinking of you working at the World Bank and in different countries and different communities. And the different people's language needs are probably going to vary. And it seems like it would be so hard to have a one-size-fits-all approach to access and translation, and whether things need to be in print or orally, or translated into multiple languages or single language. So I guess from a principled perspective, I think honoring self-determination, finding what the Indigenous peoples need and being responsive to that is probably my most general suggestion. In terms of translation of, maybe if you're talking about documents and so on, I think one interesting phenomenon coming out of the linguistics community, and obviously I'm not a linguist, I'm a lawyer, so I've only just begun to understand this, but is the field of computational linguistics and the extent to which programming and translation programs may be able to help to up-level the generation of materials when you're talking about, I don't know, hundreds of pages of legal documents, or other things that would be, hard to do word by word with a human translator. I have mixed feelings about it, and a lot of the Indigenous people I work with have mixed feelings about it because our languages are so precious. And I think Paul John was talking about some of the pitfalls if you get the word wrong. But if we're really going to be talking about using languages in all of our work and all of our settings, I am interested in the ways that Indigenous peoples may embrace computational linguistics as one of the tools going forward.
Thank you so much, Professor. Okay, we do have a question from the audience, and I'm actually going to turn to you, Paul John, as the only Cree lawyer in the territory larger than France. How do you think or hope legal education could change in order to bring up more lawyers who speak and or value Indigenous languages?
Oh, boy. Well, I mean, there's a couple of things that I'm involved with that it just seems to be the way institutions are going. When I was asked to teach an Indigenous law course by a university, I had tauntingly said, sure, I'll do it, but I don't want to teach what you guys are teaching. Because it was always, I mean, now I'm going to start showing my age, but it was always sentencing circles. It always seemed to start with criminal issues or very broad issues. And I said, what I'd like to teach is a Cree property law course. I was a very bold dean who said, sure, go ahead. And then, again, I had to work harder because I went over-promised. So for 3-4 years with McGill University, University of Ottawa, Université du Québec à Montréal, we gave a Cree property law course. And what was very interesting was the impact not only on the non-native students, but on the Cree students, recognizing that the things that we took for granted traditionally, it had normative force, and it did shape behavior, and it did result in real property rights for people. So I almost forgot the question again. The other one is, in the last year, my staff and staff from other companies, I've been giving language courses in Cree, and that's opening up a whole area. Again, to come back just to this conference, I mean, events like this open the eyes, not just for the world, but for people at home. And it helps elevate the things that we do every day. It helps elevate interests. Next week, I'm going to be visiting a grade 6 class so that they don't think that the only place they can work is the clinic, the school, and the band office. Yeah. And I'm going to tell them absolutely about being here today. So hopefully that means in 7 years, you're going to have a whole Cree panel in front of you.
Fantastic. Okay. We have another question that we're not fully understanding, but we will do our best to interpret. Here you go, Leo. What is the scope What is the scope for protection or accountability in international law in regards to erasure or attempted erasure? We're going to assume that's erase, borrar, of Indigenous languages when it results in, or the intent is that it will result in cultural genocide. If you can answer that, we will try. You got a hard on. 5 minutes. Okay, so you have 2 minutes, and then we have one last question.
Okay.
And we'll close.
Yeah, very quickly. Basically, any perpetration of a violation of a right that is protected by international law instruments gives the possibility to seek remedies in international law, but before doing that, there is a principle that is the principle of prior exhaustion of domestic remedy. That is, you have to give the domestic courts the possibility of addressing the legal issues that you want to bring later at the international level. So all of the regional human rights systems, such as those of the Organization of American States called Inter-American Human Rights System, the African and People's Human Rights System, and the European Human Rights System, do have in place sort of a treaty supervisory body, usually it's called the Commission, and then a court that adjudicate over cases regarding the non-compliance with the main regional human rights treaty. And so when the court gets to process a case, the courts will look into issues such as exhaustion of domestic remedies, and in doing that, it has to address whether or not the victims have given the state courts the possibility to address the issue. Even though this is a principle, there are exceptions, such as, for example, unwarranted delay when you file a case with the court, for example, on native languages or trying attempts to erase native languages from communities. The court almost never issue a decision or takes too long. You can actually bring the case to the Commission, and after that to the court. Another exception to the rule of exhaustive and domestic remedies is the lack of an effective remedy in the country's legal system. Sometimes countries offer a menu of legal recourses that citizens can file to access justice, but sometimes the type of the legal issue or the right in question has not been addressed in a sort of a effective remedy. The remedy may exist, but in practice it does not provide for the protection of the right in question. And when we are in a situation like that, we can also bring the case to the different commissions in the regional human rights system. A third exception to that rule is the lack of due process of law. You can file an effective remedy, but the courts do not provide for due process of law guarantees when processing the different remedies. So look into the situation, give the courts the chance to address the issue. If not, and if you are in one of those three exceptions, bring the case to the regional human rights body, and after that to the court for the final adjudication.
We hope that answered the question. Okay, we're going to do one last one. We have 2 minutes left. Do you think, and I'm going to give this to Paul John. I'm sorry I don't field you another one, Professor, but this is for him. Do you think that Indigenous peoples can strengthen government support for Indigenous languages by discussing cultural values and stories that are preserved through language?
Absolutely, and I've lived some practical examples that demonstrate how imperative it is and how efficient it is to begin with the values. We had a very real situation, and we're still living it today, where there's a conflict between Indigenous land users and occupiers of the territory and non-native people coming in with vacation leases and summer homes and things like that. Once we sat down with everybody that was involved and we asked the Cree community members, you know, what was their concerns, what was their, and this is when it came out that Cree land tenure, it's based on value. It's based on the community's assessment of what your priorities and what your values are. If you can demonstrate that you will care for the land, that you have knowledge of land, that you'll care for the animals, and that you won't be exclusive, and you'll take care of your neighbors and you'll accommodate them, everybody will respect your title. So it was just a question of getting that out, allowing that relationship to be built between, a lot of times the trappers just say, can I just speak to the guy? Because then he'll see that when he's away in the winter, I can watch over his cabin and, you know, make sure that it doesn't get disturbed, and I can even let him know what's going on. And then, you know, they create the sense of partnership, and then they start working together. So it's not only possible, I'd say it's imperative, and it's the most efficient.
Well, thank you to our most distinguished panelists, Kristen, Leo, Paul John, and to Charles DeLeva for helping put this together, and Assel for giving exposure to such an important issue, where today what we've seen is that language is not just an artifact of cultural heritage, but it's very fundamental and critical for the right to self-determination and cultural survival and the defense of the human rights of Indigenous peoples throughout the world. Thank you so much for joining us. This was a really big room, but we got great questions, and thanks. Have a lovely afternoon.